Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court, while upholding the right to dissent, has observed that every criticism is not offence, and if it were thought so, democracy would not survive. The police should be sensitized about freedom of speech granted by the Constitution, the court added, throwing out a case against a man who had made adverse comments on the scrapping of Article 370, which granted special status to Jammu and Kashmir. The Constitution of India, under Article 19(1)(a), guarantees freedom of speech and expression. Under the said guarantee, every citizen has the right to offer criticism of the action of abrogation of Article 370, or for that matter, every decision of the state. He has the right to say he is unhappy with any decision of the state, the court said. Noting a discrepancy in the process of empaneling of army officers, the Supreme Court has directed the centre to clarify the procedure for male officers as compared to their female counterparts. A bench of Chief Justice D.Y. Chandrachud and Justice J.B. Pardiwala and Justice Manoj Mishra asked Attorney General R. Venkataramani to file an affidavit explaining the central government's position. The direction came after senior advocate Huzaifa Ahmadi, appearing for women army officers, alleged discrimination in the empanelment of women officers. He referred to an earlier order passed by the Apex Court last year on November 3rd and submitted that it required the consideration of all women officers who are considered by the earlier Special Selection Board 3B for promotion as colonel, except for these officers who are already empaneled. Hence, it is submitted that considering other empaneled officers would amount to a breach of the directions, he said. Fiscal management by the states is an issue the union government has to be concerned about as it impacts the nation's economy. The Supreme Court observed and advised the centre and the Kerala government to iron out their differences, a cap on net borrowing by the southern state. The Supreme Court made the observation while it was hearing a suit filed by the Kerala government accusing the Union of India of interfering in exercise of its exclusive, autonomous and plenary powers to regulate the state's finances by imposing a ceiling on borrowing. The dialogue between the centre and the state must not stop merely because of the pending suit, the court said, while stressing on the need to resolve the issue. The Supreme Court is set to examine whether an accused not arrested during the prop period under the Prevention of Money Laundering Act (PMLA) will still be required to meet the twin bail condition. The division bench of Justice Abhayas Oka and Justice Ujjal Bhuyan has issued notice in a case where the question emerged that if pursuant to the summons issued by the special court, the accused appears before the special court, whether he is required to apply for the bail in terms of Section 437 of the Code of Criminal Procedure 1973, or whether such a bail plea will be governed by the twin conditions imposed by the Section 45 of the PMLA Act. The court shall also look into the question as to one's cognizance of a complaint filed under Section 44 of the Act taken by the Special Court under the Prevention of Money Laundering Act 2002, the power to arrest by ED vesting under Section 19 of the PMLA Act ceases to exist or not. Now let's have an overview of High Courts. Asking a husband to live separately from his family amounts to cruelty by his wife, the Delhi High Court has said. The court also stated that in a marriage, the intent is to share the responsibilities of a future life, and the husband expecting his wife to do household chores cannot be termed as cruelty. Asking a married woman to do household work cannot be equated to the work of a help, as it shall be counted as her love and affection for the family. The court's observation came while dealing with an appeal by a man against a family court order refusing to dissolve his marriage on the grounds of cruelty by his wife. The appellant husband, a CISF member, said he was aggrieved by the respondent wife's non-contribution in household chores, abandonment of matrimonial home, and false implication in criminal cases at her behest. Consequently, a complaint filed by a working journalist under the Unfair Labour Practices Act before an industrial court would not be maintainable, a division bench of Justice Nitin Jamdar and Justice Sandeep Marne has observed while observing that they enjoy a special status under provisions of the Working Journalist Act and have a recourse to settle their disputes under the Industrial Disputes Act. The judgment came on petitions filed by two working journalists challenging order of the Industrial Court in 2019, rejecting their complaints on the ground that working journalists did not fall within the terms of employees or workmen under the Prevention of Unfair Labour Practices Act. The bench of the Bombay High Court noted that Working Journalist Act 1955 has already established a mechanism for dispute resolution under the Industrial Disputes Act, as working journalists constitute a different class with unique privileges and protections in their employment. The Allahabad High Court has held that non-appearance of the counsel for the applicant amounts to professional misconduct and is also tantamount to bench hunting or forum shopping, and the mere pendency of the bail application cannot accrue any right in favor of the applicant. The court was hearing an application seeking a grant of anticipatory bail which was filed in the year 2019. Further, the court stated that mere pendency of the bail application cannot accrue any right in favor of the applicant. It cannot be allowed to swing years together in the clock of pendency. The applicant cannot be permitted to dilute the stream of justice by repeatedly remaining absent from judicial proceedings without any reasonable explanation. The absence of any reason for non-appearance is a blatant abuse of the process of law, even though the order is available and accessible to all on the websites of the High Court. The Rajasthan High Court has opined that to establish offence under the PMLA, the Enforcement Directorate must demonstrate that procurement of the property as the proceeds of crime are derived from the criminal activity from the predicate offences prescribed under Part A and Part B of the Schedule offences. It is also an established proposition that though the offences of money laundering is separate standalone offence, the proceeds of crime ought to have preceded the commission of predicate offences and thereafter laundered over. Further, to release the accused on bail under the PMLA, the court has to see the grounds for believing that accused is not guilty of such offence. The Calcutta High Court, while allowing a revision petition against an order passed by Special Judge Boxo in an application filed by the prosecution for taking blood samples of the accused, the victim girl and the minor baby of the victim girl for the purpose of DNA profiling, held that the order directing further investigation by the learned court under Section 53A of the CRPC is in the form of collecting DNA evidence to be submitted by supplementary charge sheet was contrary to the procedure established under the CRPC. The court said that Section 311 cannot be used for filing up lecané through recall or examination of witnesses for the purpose of creating fresh evidence. The single-judge bench of the Jharkhand High Court has held that in case of composite negligence where the damage or death is caused to any person by two or more wrongdoers, they may be either joint or independent tortfeasors. They are jointly and severally liable. The injured person has the choice to claim the whole damage against all or any of them, since it is a case of composite negligence. Moving on to international news this week. France has enshrined the right to abortion in its constitution, a world's first welcomed by women's rights groups as historic and harshly criticized by anti-abortion groups. Abortion rights are more widely accepted in France than in the United States and many other countries, with polls showing around 80% of French people back the fact that abortion is legal. Women have had legal right to abortion in France since the 1974 law, which many harshly criticized at the time. Pakistan's Supreme Court has ruled that former Prime Minister Zulfikar Ali Bhutto, who was hanged 44 years ago after being convicted of murder, didn't get a fair trial. The ruling came in response to a judicial reference filed by Bhutto Zardari's father, Asif Ali Zardari, during his tenure as president in 2011. It sought an opinion by the top court on revisiting the death sentence awarded to the PPP founder. The US Supreme Court handed Donald Trump a major victory as he campaigns to regain the presidency, overturning a judicial decision that had excluded him from Colorado ballot under a constitutional provision involving insurrection for inciting and supporting the January 6, 2021 Capitol attack. The justices unanimously reserved a December 19th decision by Colorado's top court to kick Trump off the state's Republican primary ballot on Tuesday after finding that the US Constitution's 14th Amendment disqualified him from again holding the public office. Trump is the front-runner for the Republican nomination to challenge Democratic President Joe Biden in the November 5th US election. In the end, we have miscellaneous news. In an appeal, Make My Trip, a leading online travel operator, filed before the Supreme Court, alleged that the Google Ads program infringed on its trademark rights. The company claims that Booking.com, a competitor, has been able to purchase the Make My Trip keyword through Google Ads, leading to sponsored links to Booking.com appearing in Google search result for the keyword. Make My Trip asserts that this practice diverts its business to a competitor and dilutes the distinctive character it has built over its 24 years of operation. The company contends that Google's auction-based system, where advertisers bid on keywords, allows competitors to associate themselves with Make My Trip, causing confusion among consumers. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.